Before we begin, we'd like to give special thanks to all of our sponsors for helping make this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 5 consecutive years. And thank you to our platinum sponsors, AuraSure Technologies, Psychmedics, Samba Safety, UKG, and Quest Diagnostics.
Hello, and thank you so much for joining us for another session of Day with DISA. Today's session is on background screening with a focus on getting back to the basics, plus a little bit more. Today, we're joined by Pamela Devata, partner at Seyfarth Shaw, and Morgan Reynolds, Director of Governance and Risk at DISA Global Solutions. Pam, Morgan, how are you guys doing today?
I'm doing great, Thomas. Thanks for having me.
I'm doing well, thanks. Excited to be here for another Day with DISA.
Great. Well, before we jump into the presentation, I want to remind everyone that if you have any questions, use the Q&A button at the bottom right. If there's any questions we're unable to answer today, we'll reach back out to you after Day with DISA. Additionally, we'll make a copy of this presentation available for download on the Materials tab after the session. With that being said, Pam, the floor is yours.
Thanks so much, Thomas. And I'm so thrilled to be here today with everyone for Day with DISA, and especially with my esteemed colleague, Morgan Reynolds, who we work together a lot. So thankful to be here. Let's go ahead and dive in. Today, we're going to get back to basics. So what are we really talking about? We're talking about your responsibilities under the Federal Fair Credit Reporting Act. What is the same, what has changed, and a few different tidbits of best practices to make sure that you are really comfortable with your responsibilities under the law. All right, so let's go ahead and dive in. As Thomas said, I'm Pam Devata. I'm a labor and employment partner at Seyfarth Shaw in Chicago. Before we get started, we did want to have our legal disclaimer because obviously I am an attorney. But I'm not giving any legal advice or counsel, neither is Morgan today. So really, this is for informational purposes only. If you do have questions, as Thomas indicated, you could put them in the chat. We are going to try and get to as many of those as possible, but please understand we can't have very factually specific questions because we're not going to be giving any legal advice today. All right, let's dive into the substance now of what we're going to really talk about today. We're going to focus on responsibilities for you under the Fair Credit Reporting Act. And as an employer, and really as anyone who utilizes any information from a third-party consumer reporting agency, you have 4 main responsibilities under the Act. So the first is going to be you must have a permissible purpose to actually get information under the Fair Credit Reporting Act. The general and most common utilized is going to be employment screening. Oftentimes tenant screening or insurance will also be under those, or granting of credit, like say, for example, someone is trying to get a mortgage or a loan, for example. Permissible purpose, though, and purposes of what we're talking about today, we're generally going to be focusing on the requirements under the employment purposes prong. And you should note that employment purposes has been defined extremely broadly under the Fair Credit Reporting Act in terms of the interpretation by our regulators. There's 2 regulators. You've got the Federal Trade Commission and the Consumer Financial Protection Bureau. They have opined that employment purposes is going to be extended pretty broadly into things like volunteers, independent contractors, gig economy, for example. So you really need to understand what is the permissible purpose you have to run a background check in the first place. And you're going to need to certify that information to your background screening company like DISA, for example, either in an agreement or through the ordering platform when you're making the orders. The second thing that you're going to need to do is have a disclosure and authorization. I'm going to talk at length, and so is Morgan, about the different responsibilities, some of the different nuances, some of the recent case law and updates over the last few years. There has been quite a bit of litigation since 2020 and even prior to that, specifically in the Ninth Circuit, which is sort of California area. But we will talk about that in great detail and what you really need to be wary about and what you need to understand. The third responsibility for an employer under the FCRA is going to be following the adverse action process. For a non-employment purpose, it's a one-step adverse action process. We're going to be focused on what's called the 2 or 3-step adverse action process today. We're going to do a deep dive into that of the pre-adverse action requirements, the waiting period, then the adverse action requirements. In addition to the Federal Fair Credit Reporting Act, there are a myriad of different nuances under state and local law. We are not going to be doing a huge deep dive into those, but we're going to be touching on some of those that you can make sure that you understand and are aware of. And then finally, last but certainly not least, you must give a promise or a certification that you as an employer are going to follow all of the other things that we just talked about: permissible purpose, disclosure, and authorization. That's past tense. You have obtained, that you will obtain an adverse action or follow the adverse action process if applicable. And then finally, that you will follow all equal employment opportunity laws. So understand that. Why does it matter? Well, it matters because there is a ton of litigation in this area. And what we are seeing, what we have seen really over the last few years, is an increase not only in single plaintiff cases, but class action litigation. There's 2 types of different lawsuits that can be brought under the Federal Fair Credit Reporting Act. One, a negligent violation, and the second is a willful violation. Negligent violations we don't see as often as willful violations. And the reason is because if you have a negligent violation, you're basically saying, hey, the consumer is saying, hey, employer, you did not follow your obligations under the law. You had a duty to me. You breached that duty. It's really the definition of negligence. And therefore, I want to get damages. They can get actual damages. Usually it's back pay, or sometimes compensatory emotional distress damages is the most common type, and attorney's fees if they can prove liability. The reason why we don't see negligent violations except in a single plaintiff case is because many of these cases are brought as class actions. So it's 1 or 2 people that bring a case, and they bring it on behalf of a similarly situated group of individuals who they are arguing are substantially similar in their situation, that were harmed in the same sort of way. A willful violation, the reason they do this is because for a willful violation, they can actually try to get actual damages and attorney's fees, or more likely they ask for statutory damages, and it's between $100 to $1,000 per violation. And if they can prove willfulness, which is defined as reckless disregard for the law, they can also get punitive damages. So think about this. The reason why it's so important that you understand, that you are revisiting, that we are going back to basics with Day with DISA, is that you have potential liability going back either the earlier of 2 years from the date the person knew or should have known, or 5 years from the date of the report. So let's take a typical disclosure case. And before we get into the nitty-gritty of the disclosure and authorizations, if you think about it, if someone has been given a disclosure form, they understand that a background check has been run. So, and they bring a lawsuit saying that the disclosure is somehow in violation of the law, then what's going to happen is you're going to have a potential class action going back 2 years from the date that they file that lawsuit, the date that they knew or should have known. So you've got 2 years of liability. So how many background checks have you run in the last 2 years with that same disclosure or authorization form that is alleged to be in violation, times $100 or times $1,000 plus punitive damages? So you have to understand that is going to be huge amounts of money. So the exposure is enormous. That's why we're talking about what you need to do, and we're getting back to basics.
And so just Pam, you said something that I want to highlight for our audience. You said there was a ton of litigation here. So when we're talking about a ton of litigation for the audience, like the numbers are breathtaking when you see the increase. I think it was over 5,000 federal cases and more than that in the state level. Like, what are we talking about with a ton of litigation?
Yeah, it's a great question, Morgan. And so, this litigation actually started back in 2015, if you will, but there was very, very little litigation at that point in time. And then we saw a huge increase in like 2019, 2020, and we're still seeing that as an upward trend. So in terms of the number of cases, we're seeing nationwide class actions. They're being filed all over the country. So a lot of them are being filed in certain jurisdictions like California, for example. Some of them are being filed in Virginia, in Florida, in Minnesota, in Pennsylvania. Those are the hot areas where we're seeing these cases being filed. But again, they're being filed on a nationwide basis, and they're being filed against every size company. Obviously, large companies who are national companies who have a large footprint, but in every single sector. We're seeing them in hospitality, we're seeing them in retail, we're seeing them in all different types of industry. Staffing is a huge area where we're seeing them. So, you know, it used to be, we thought that there was a time where we wouldn't see these anymore after the Ramirez TransUnion case, for example, that came down with the United States Supreme Court about harm. That has really not put a dent whatsoever, because the argument is when someone does not get a form that they believe gives them their rights in the form and the substance that they're supposed to have, that they are harmed by a privacy right or an informational right. So we're still fighting that in multiple jurisdictions, but every day there is a new FCRA class action that is filed.
Yeah, and so Pam just hit on what I was going to follow up with is the 2-year statute of limitation. You could be sitting there, some of our attendees probably go 2 years and they haven't not hired someone because of an employment background check, right? They get some hits, they get some records, but they haven't gone through the pre-adverse action process. But you still need to pay attention to this, because it's the harm piece that should resonate, because even if the person was hired, they can still sue you potentially for technical violations. And the 2 years is not just, you know, people that weren't hired. It's every background check could be at risk if there's willful technical violations.
That's a great point, Morgan. I mean, frankly, most of the cases we see are not by people for disclosure and authorization cases. They're actually not brought by people who did not get the job. Adverse action cases are by those people that did not get the job, but generally disclosure cases are people that actually you hired.
Yeah. So anyway, I just want our audience to understand that even if you're sitting there like, I haven't had very many hits, my people are good, you still need to be, you know, paying attention and have your antenna up as we get into this first area, the disclosure and authorization form section.
Great point. So let's get into the nitty-gritty about what's required. First of all, as we said, these claims are still happening all over the place. What the law requires, and the issue is the law, let's be clear, it's an antiquated law. It's over 40 years old. It has only been amended a couple of times. And, you know, when the law was actually passed, it talks about faxes, like the internet wasn't even a thing when this law was passed, right? Email was not invented when this law was passed. So it's an antiquated law that has to catch up to the times and really hasn't. But basically what it says is that a employer, prior to obtaining a background check from a third-party consumer reporting agency, must give the person a disclosure. That disclosure must be in a document consisting solely of the disclosure, only the disclosure, that a consumer report must be obtained. It must be standalone and it must be separate. The problem is that the statute says in the very next sentence that you also must obtain a written authorization from that person. So you must give information about what's going to be obtained, and you must get that person's authorization. And oh, by the way, the statute says they can be on the same form. The problem is, how can you have a clear and conspicuous disclosure consisting solely of the disclosure if it's on the same form as an authorization? And the answer is it's very difficult. It's not impossible, but it's very, very difficult to do. So the best practice tip here, and again, we're not giving legal advice, but the best practice tip is really to separate those, having a standalone disclosure and a separate and distinct document that is the authorization. The authorization can have whatever it wants in it, as long as it is a separate and distinct document. So what have we seen with the case law? We're going to go and talk about some recent developments. What we have seen is that anything extraneous other than just here, I am authorizing this background check and here's what it consists of, and or I am going to be providing these background checks from this background check company will be challenged. References to you have the right to inspect a file or the notice and the scope of an investigative consumer report. The separate type of consumer report. There's a garden variety consumer report. There's a separate type of investigative consumer report under the federal law. There's even a different definition under California law. But a lot of times for a good user experience, what used to happen was everybody would put everything in one document. So there were less forms. That is not advisable anymore, because while you have a better user experience, perhaps you're going to get sued if you don't have separate, distinct forms. So references to getting a copy of the report, which is required under certain jurisdictions. If you put that in your disclosure, again, not the authorization, not other state law notices, not another document, but if you put it in your document entitled disclosure, that could be a problem. Discussions of having a background check being allowed or being run throughout a person's employment if they are hired might be deemed to be extraneous information. I mentioned before that we've got, in addition to the Federal Fair Credit Reporting Act, you've got a myriad of state law and local laws. You actually have the obligation to provide some of that information to individuals. Like, for example, California has a separate disclosure that you have to provide. It has to be standalone and separate. There's some other state laws, California, Minnesota, Oklahoma, require a checkbox, for example. If you put those pieces of information that are required under state law in your federal FCRA disclosure, those potentially may be deemed to be extraneous. There have been court decisions that have held that. And many other of these types of items. I will tell you, as a good takeaway, an employer can, so this is a good thing, you can provide the document at the same time as other documents, but you want to make sure you understand, number one, it's separate and distinct and standalone. It's not, put at the bottom of the application like a paragraph, that it is not given in a stack of papers or in the middle of a stack of documents. You want to keep it as separate and distinct as possible, whether it's electronic or it's in a paper format. And we review systems literally every day to make sure that you've got that argument that it's separate and apart and distinct. The authorization does not need to be separate from the other employment documents. You can have that authorization be part and parcel of other things. It's a good idea to have it separate, but it's not required. And then in addition, there's a whole big list of other state law requirements. Generally speaking, we recommend that if you're going to have your disclosure forms for employment purposes, that you've got your disclosure for background checks, that you've got, if you're doing an investigative consumer report disclosure, you have a separate notice that has the requisite language that you need to have, that you've got a California notice if you're in California, if you're a person that lives or works in California, that you have your other state law notices that might have the equivalent of some of the other notices with, for example, Washington, New York, many others. And then you have your authorization as a separate and distinct form. It's a lot, and the law is ever changing. My litigation tip at the very top of this slide, review your forms often, and I would say at least on an annual basis.
So before we move on, I just want to hit on a couple of things, Pam, that you wonderfully mentioned. But on the disclosure side, one of the things that I'm seeing outreach from applicants, consumers about, is the type of services run, right? So we'll see them ask, it's said that there'll be a catch-all which lists like every service that could potentially run, and things like credit and things that maybe aren't going to be run as part of the package. Would that be extraneous, or is that okay?
Yeah, great question. So I will tell you that in certain jurisdictions, if you say that your credit's a great example. In certain jurisdictions, if you say that you're running credit and you are not, that could be extraneous and illegal, for example, depending on the time that you're doing it. New York is one example there. You might also, if you're running credit, if you are running credit, you actually have to say you're running credit, and there may be additional documents and forms that you may be needing to run as well. And so the idea is going to be, you really want to narrowly tailor this to what you are getting and what you are running. and make it as short and sweet as possible. Generally speaking, a disclosure and authorization, a disclosure standalone form is going to be 2 to 3 to 4 sentences. There is a lot of discussion about whether or not you need to have your background screening company name in the disclosure and authorization form. The disclosure specifically, authorization you do. But in the disclosure form, the answer is the only place you have to have that is in California. So you put it in the California form. Is it bad to have it? No. Will it be deemed to be extraneous? I've never, ever seen a case that has held that it is extraneous. So I'm not saying that you should not have your background screening company. I actually think that it helps in the clear and conspicuous. So that's the fundamental friction. What's clear and conspicuous? What's extraneous? So have your forms reviewed internally. Have them reviewed by legal counsel that knows what they're doing, that practices in this area. And it's often a great idea to get these forms, for example, samples from your background screening company, but understand at the end of the day, an employer is the only person that can be sued on a disclosure claim. It's your responsibility under the law.
Yeah, and then a couple other things that you mentioned that I wanted to highlight for the audience is the too many forms comment on my side, on the DISA side. That's the most common complaint I would say we get from our users, is they don't like the 2 forms. But as we've talked about, there's a reason why they're separate. There's a reason why there's a 1-page disclosure and a 1-page authorization, and then the California. And we understand it's not the easiest process, but when I look at the explosion of litigation, I think that it should be worth the time to have more than 1 form. The evergreen forms is another point that I wanted our audience to take home, is that, each time you're rerunning the person, the best practice would be to have them sign a new form, because look, you're updating your forms at least annually, right? You're following Pam's advice at the top here. You're reviewing them and making slight alterations, so you might as well get them on your newest paper. And then in terms of good governance, everyone needs to be cognizant of remote workers. And so you may only have offices in certain states, but it's not just where your offices are, it's where the person lives. So Pam's comment about, California, you may not do business in California, so you think, but if your recruiters are out there and they find someone in California, you could potentially need to follow California law, or the other states we've talked about. So just in terms of that, a 50-state review of all the requirements is something that we would recommend, just to be extra safe.
Absolutely, Morgan, because really it's where the person can sue you, right? They can sue you where the harm is, and the harm potentially occurs where they live and or where they might have worked if they don't get the job, or where they believe they were given that information where the job was. So you need to be really careful about that.
Yeah, and courts are going to be very sympathetic to the workers, to the plaintiffs in finding standing to bring suit. So, taking the most expansive definition of where they could sue you is probably the best way to do it.
Absolutely. All right. So the takeaways for that: make sure you review your forms on an annual basis, get good counsel. Don't rely on forms that are given to you. You can use them as a starting point, and make sure you do it often, at least annually. All right, let's go to the next topic, which is adverse action. Again, we're going to talk about sort of the 3 steps here in adverse action, and the first of which is pre-adverse action. So when we talk about adverse action, it's really a very broad term. It's literally defined as any action that's taken in whole or in part on a consumer report that's adverse to the interest of the consumer. Well, what does that mean? That doesn't just mean that if you reject the offer. Of course, it does mean that if you reject that person's offer. It could also mean that if you don't hire someone to a specific position, but you hire them to a different position. Or it could mean that you are running a check on someone for a promotion and they don't get the promotion, but they still maintain the current job. So you need to understand that what adverse action is, but understand it's going to be defined very broadly. So it's little bit of a legal fiction here, but there's 3 steps, right? Pre-adverse, waiting period, and adverse. We're going to get to those all in order. So the pre-adverse action is basically an opportunity. We call it due process, right? It's basically an opportunity for you as the employer to provide a copy of the report to the potential employee or applicant to say, listen, we're thinking about potentially taking adverse action on you. We're thinking about rejecting your employment offer. We're thinking about not allowing you to start on a certain date. We're thinking about not giving you that promotion. Here is a copy of the background report on which we are thinking about taking action based in whole or in part on that. Here's a copy of your summary of rights under the federal law. And there may be other additional notices. So for example, if you're in Massachusetts, you have to send a different notice. If you're in New York, you have to send a different notice. If you're in Washington or New Jersey, you have to send a different notice. There may also be some other state and local nuances that you actually have to put in that letter, and an analysis that you have to do that we're going to talk a little bit more in detail on as well. But understand it's not just one letter necessarily that can one size fits all. It may be needing to be customized based on state or local jurisdiction. Let's say you're in a jurisdiction that you do not have to customize it, right? That does not have specific, ban the box law that allows you to do certain information. So you're not in LA, you're not in California, you're not in New York, you're not in Illinois. You're in a state that does not have one of those requirements. You send the pre-adverse action letter with a copy of the report, copy of the summary of rights, then what? Well, now we go to the next slide. We are waiting. The waiting period is defined as a reasonable period of time. It's actually not defined of what that means under the law, but you must wait a reasonable period of time between the pre-adverse action notice and the adverse action notice. And the Federal Trade Commission, again, one of the 2 regulators, has opined that a reasonable period of time is 5 business days. Now, it's very factually specific, so it might be shorter, it might be longer, but you want to understand, how are you providing this information? Are you giving it to the individual? Are you emailing it to the person, which the FTC has said is allowable if they have agreed to receive notices electronically that's applicable under the e-sign Act, for example. But you need to understand. So for example, there are other jurisdictional requirements. New York City, you have to have 3 days from the receipt of the report. There's a whole different fun webinar and millions of things we could talk about with New York City. Arguably it requires a bifurcated process, tremendously complex. We have been seeing a lot of litigation on this, both with the New York AG's office, as well as private rights of action in New York law. So if you don't know about that, make sure that you have operations in New York City, make sure that you talk to folks to get more information about that, and reach out to DISA to see where you can get some more information about that. There may also be Fair Chance Act forms required. Los Angeles, New York City require a very specific, detailed questions that be answered and provided to the applicant. They don't have to be on that exact form, although they have to be substantially similar. So why in the world wouldn't you just use the exact form that they're asking about? And that you have to actually fill that out and provide that during that pre-adverse action process. And then finally, in certain other jurisdictions like San Francisco, you have to wait an additional time. So not 5 days, but 7 days. Now, arguably 5 business days is the same as 7 calendar days. So if you wait 5 business days, you're probably okay in most places, with the one exception of Philadelphia, who arguably requires 10 days. So what are some tips, and where are we seeing some issues with sort of best practices and what's been updated in the world of adverse action? We'll go ahead and go to the next slide. When you go to adverse action, you do the pre, you wait. Now you have the adverse action letter, right? So this is a notification of the final decision. We're going to withdraw the job offer. We're going to terminate you. Okay. Side note, never, ever, ever, if you can avoid it, hire someone prior to their background check being completed. It is so much more challenging to terminate someone who has access to your people, to your property, to your employees, to your customers, than it is to withdraw a job offer. That's my customer service announcement for the day. It's my PSA for the day. But in that letter, there's a variety. There's about 15 very specific points that you need to have. You should get a template letter from your lawyer, inside or outside. You have to have the consumer reporting agency's contact info. You have to say that they're not the decision maker and they don't know why the decision was made. You have to give them an opportunity to obtain another free copy of the report, even though they've already gotten a free copy of the report with the pre-adverse action. And they have the right to dispute any information in the report. So all of those things have to be, number one, in the pre-adverse. They also have to be in the adverse. It can be done orally or verbally. We strongly recommend against that because there's no way you can meet all of the requirements that you need to make in a verbal statement. Okay, so what do we need to do then? What you want to make sure is that some do's and don'ts to avoid litigation is what we're going to talk a little bit about next. Number one, we want to make sure that you understand the FCRA and the specific adverse action requirements. We talked about ban the box, for example. Ban the box is a sort of a litany of what we basically say is going to be banning the box of asking about criminal history on the application. The problem is these ban the box laws have taken on a life of their own. And now the large majority of them actually talk about what you as an employer have to add to your pre-adverse or adverse process. And I think, Morgan, there was another session that was previously done with Day with DISA on adverse action. Is that right?
Yeah, so Eden Hutchinson from our compliance team, yesterday, she did a full session on pre-adverse action and adverse action. And if you're not getting enough from this short period sheet, you can rewatch that one for Day with DISA. But Eden's incredible. I'm sure everyone will be entertained by Eden's adverse action seminar.
Awesome. Yeah, highly recommend that as well. The other thing that you want to make sure you're doing is when you are going through that pre-adverse and adverse action process, from the time frame that you are getting the background check back, reviewing it, assessing it, doing all of the different things, and we could go in short order and talk about the EEOC criminal history guidelines and all of the state and local nuances, and you're doing your individualized assessment and you're analyzing this, right? We're really just talking about the FCRA right now, but all of those things you have to do, you want to make sure that until you send that adverse action letter, your systems are marking this as either review or pre-adverse. So if you deem someone ineligible in a hiring system, but you're still in that pre-adverse action stage, that can be used against you. So you want to use language such as review or pre-adverse or pending while that pre-adverse and waiting period is happening.
So is that something you've seen, Pam, in the like applicant tracking systems that are so common these days, is that the recruiter would update them as ineligible while the pre-adverse action period is ongoing?
Yeah, unfortunately, the older applicant tracking systems that haven't been updated would have, the different statuses would go from, background check, for example, is often a common status, or pending background check, to then eligible, ineligible, right? And so at this point, you really need a different one that says pre-adverse or review or pending, because really what's happening is, remember, even though we've made arguably the preliminary decision that we might not hire someone, we haven't actually made that decision until after we've sent the pre-adverse, we've waited the requisite time, and then only when we send the adverse letter can we change that to an ineligible or does not meet or does not hire or adverse action.
Yeah, and I've seen some of our clients who, they will send the pre-adverse frequently, potentially considering it, but then they have metrics on 50% or more of those they ultimately hire, because it's anything that could potentially cause it. And so when we go back to Pam's presentation earlier, she said it's anything potentially. I would say you would want to have some where you eventually hired them when you're sending the pre-adverse, just to show you're being as expansive in sending the pre-adverse as possible. One of the things on the CRA side, on the Consumer Reporting Agency side, that we get is clients requesting us to automatically send the pre-adverse on behalf of them. What would you, and I know what your answer is, but I'm going to cue you up on this anyway, Pam. What would you say to the automatic dispatch of the pre-adverse if it meets certain levels?
Yeah, I mean, so what I would say is you can never have an auto pre and post. That's really the every single time answer. And what I mean by that is, you know, you've got the EEOC criminal history guidelines, you've got all these other myriads of different state and local laws where you're going to have to do a comprehensive analysis, right? So you can't just have, for example, a matrix that has some of the things built in, but it's never ever going to be able to have a full individualized assessment where you automatically have the pre-adverse sent and automatically have the adverse sent. So you could do it where you have the pre-adverse sent and then the adverse is not automated, although be very, very careful, because now are you dealing with the Fair Chance Act? Have you done the things in Illinois you're supposed to do? Have you done it in those jurisdictions? So you might be able to be okay depending on what jurisdictions you're in. But then you have to go in and push the button or make the analysis for the adverse. The other option is that you do all of the analysis, you look at everything, you fill it in any worksheets or any Fair Chance Act forms, you put everything in the pre-adverse that you need to, then you say, please send a pre-adverse either through your Consumer Reporting Agency system or through yourself. Then you can automatically send the adverse, assuming there has not been a dispute of the information, saying that the person is saying that the information is incorrect, and or assuming they didn't provide you new information. So if they've said to you, no, wait a second, yeah, I see that, it's actually right, but I want to give you my certificate of disabilities from New York. Or please understand that, you know, since that time, I've been in this job training and I've gotten these extra degrees and whatever it is, mitigating factors. So the answer is no, you should not ask your consumer reporting agency to do an auto pre, auto post. And I'm not aware of many or any that will do that for you.
Yeah, we won't do that, but it is something that gets requested. And just to go back to the EEOC criminal record individualized assessment, because you hit on that a little bit. I've been around, I think, in this industry about 13 years, and that's the one thing that I think caused the best outcome for end users to understand background screening. And so why don't you go into a little bit of like the time since the offense and things to consider on the EEOC side, if you don't mind.
Sure, no problem. Yeah, so this actually was passed quite a while ago now, back in 2016, which is a little bit crazy to think about. But basically what happened is the EEOC came out with its criminal history guidance, and they basically said, look, you got to look at three things, employers, they're called the green factors. So, right, so the nature and the gravity of the offense, the time since the offense, and the relation of the job to the offense. And we're really talking about criminal history at this point. I would also argue MVRs as well, motor vehicle records.
And specifically employment, I would say,
Yeah.
Just when we talk about permissible purpose earlier, these are employment
Correct
background checks. And these are the EEOC guidelines on employment hiring.
Exactly. Because remember, this is the equal employment opportunity, right? There are some similar state laws as it relates to tenant screening, but really this is for employers. That's right. So in addition to those three green factors, the guidance says you must also, except in the most extenuating circumstances, and they do give two examples. One would be you have somebody has a manufacturing drug conviction and is working at a pharmaceutical company, or someone has a child care, a child offense, an offense against a child, and they're working at a child care facility. But except in those two specific instances, you must also do a case-by-case individualized assessment. And the other factors that they talk about are things, we talked about the nature and the gravity of offense, but facts and circumstances surrounding the offense. How long has it been since the offense? How old was the person at the time of the offense? Were they 18 and now they're 42? Or was it last year? Has there any efforts of rehabilitation? Has the person been working in the same exact job after that conviction and for how long? Has the person been bonded? Do they have character references? There's a whole litany of those types of individualized assessment factors that you're really going to want to take into account in making your determination. And some of these ban the box laws actually require you to list those. So like the New York Fair Chance Act form we were talking about has a chart that makes you list all of those different things to show that you took those into account. Illinois has a requirement that you must say why the specific conviction is either job related and or substantially job related and or is primarily associated with the risk of property or other harm. So, on that, I mean, what I would tell you is people ask, well, how in the world do you get this information? How do you do your individualized assessment? How do you gather this information? And one of the things that we talk about a lot is, you could certainly pick up the phone and call the person. You could get a lot of that information from their application, like their work history. But another way that you can actually get this information is by asking the question, again, legally appropriate question at a legally appropriate time. We are not saying to do this at all anytime prior to a conditional offer of employment. And please understand, in certain jurisdictions, it's illegal to do this generally unless and until you've had a conditional offer of employment. And certain things you're not allowed to ask about for any period of time. So certain misdemeanor marijuana convictions in certain jurisdictions, or convictions that have occurred past a certain point of time in certain jurisdictions. But we get questions all the time, and I know Morgan does as well, from employers that say to us, is there any value of asking the question, to self-disclose? Have you been convicted of a crime? Have you been convicted of a misdemeanor or a felony? Have you been convicted of something in the last 7 years? What's the value? EEOC came out, so we just took it off the application and we never put it back in. What I would tell you is I find there to be huge amounts of value in this. And the reason I say that is because if you ask it at the right time and you ask it in a meaningful way, you can also get those individualized assessment answers. So instead of just saying, have you been convicted of crime, mark yes or no. Have you been convicted of a crime? If yes, please tell me, obviously, when it occurred, what it was, what your sentence was, but then tell me about the facts and circumstances surrounding it. How old were you at the time? What rehabilitation efforts have you had? Have you been working since that time? All of those other pieces of information. So now you get it, you've gathered it, you get a full, do you have a certificate of disabilities, for example? All of those things. So then you have that information and you can utilize that in making a more fulsome analysis. And again, what we're talking about here is this is not just, a box that says check yes or no on the application. This is post conditional offer. This can be done at the same time, not on the same form as a disclosure, but at the same time as that process. You may already have to do additional requirements for the pre-adverse action that you have to get this stuff for anyway. And then the other thing that I would just also tell you is this is an opportunity here for someone to be forthcoming or not forthcoming, right? Every time someone applies, and I understand we're in a challenging labor market right now, everyone is, but every time someone applies, part of their application process is really a test, right? It's part of their applying. Do they have typos in their resume? Did they present in a professional manner, or were they using curse words during their interview? All of these things go into our determination. Well, similarly, if someone is forthcoming, if they're asked a legally appropriate question, hey, I had this situation. It was when I was 19 years old. I had a DUI. These are all the things I've done since then. I've learned my lesson, or whatever it is. That can be very helpful. Can also be very indicative when someone fails to provide that information and or what we call falsify the information. Now, if you get a background check back, the person has said no, again, legally appropriate question at the legally appropriate time, person has said no, you get a background check back, the person is falsified, we still recommend strongly sending a pre-adverse action letter because otherwise you wouldn't have known in whole or in part, but that report. But you say, we're taking this in whole or in part because of the information on the background report and because you falsified. Because you might not care about that misdemeanor marijuana conviction from 5 years ago, but they didn't tell you, and they should have. That goes potentially to their judgment. So understand that as well. The other thing I want to just add in terms of this, in terms of takeaways about adverse action, we'll go to the next slide here, is, again, you always need to make sure that you inquire about criminal history after that conditional offer. There may be times or jurisdictions where you're allowed to otherwise, but we strongly recommend doing that at that point in time. We get questions all the time about, what about arrest records? Well, remember, our legal system is that you are innocent until proven guilty. And there's also many, many jurisdictions where it's illegal to ask about arrest records. The EEOC criminal history guidance really talks about the fact that there's a disparate impact on people that are arrested more frequently than convictions, and that has a disparate impact on certain groups, specifically African-American individuals, Hispanic individuals, and men. So we strongly recommend you only ask about convictions. Lots of different restrictions on asking about sealed, expunged, restricted, juvenile, pardon, impounded records. You don't want to ask about those. So make sure you understand that as well when you're asking your question. The other sort of main takeaway I'll have, and I'll just pause for a second and ask Morgan if he has any tidbits on that criminal history question before we move on to the other takeaways.
Yeah, I think, the reason you're so good at this, Pam, is because I wrote down something as we were talking about it, about the ban the box and doing it at the legally appropriate time. And then you find out that they didn't disclose the criminal history and doing the pre-adverse. And then you answered the question that I was going to ask you right then. But I want our attendees to remember that part, right? Because we do get inquiries from clients frequently about, well, this came up, they didn't disclose it, so I don't want to hire them. What do I have to send the pre-adverse action letter? And the answer is absolutely you do, because it's the consumer report has the actual the record that you're using. So that is the thing that we get a frequent outreach about, and so I appreciate you hitting on that. And then the ban the box clause, the origin was to move the question after you'd gotten a chance to know the person, meet the person, interview the person, make the conditional offer. And so I think that's been, and there's as you said, there's a bunch of different local laws to be aware of. But I think that, understanding the origin of it helps people understand how the value can then be used now in terms of getting to know your candidate. And obviously it is a challenging hiring environment, but all of this information will help you reduce your risk of making a bad hire, because whether it's someone who ghosts you eventually or all of these things, you're trying to get to know them before you invest in them. And so we've talked about in the different Day with DISA sessions, drug testing and background screening now, and this is all just information to help you make the most informed hiring decision. So thank you for that, Pam.
Absolutely. The other couple takeaways that I will tell you is, and there's just a few more on this slide and the next, but one, have a policy, right? These are sometimes self-serving, right? But have a written policy and review your policies, review your applications, review your procedures, review to make sure that they are up to date. So for example, if you're in New York, you really don't want to say specifically New York City, anything in your job posting about that it's conditioned upon a successful completion of a background check. Put that in the offer letter, not on your job posting. So make sure you understand these things are changing and it should be reviewed really frequently. Monitor legal developments. You're attending Day with DISA, so you're doing a great job, because obviously you're getting all of this wonderful education and information that you're going to take back to the rest of your workforce to make sure your procedures and policies are really up to date. Train your employees. And I say this, and we'll go to the next slide, but it's not just the people that are working with your background check process. You may have a centralized background check function, and we strongly recommend that you do. But it's also your hiring managers. It's also your recruiters. It's everyone in that pipeline. So they understand, for example, not to ask about criminal history in the pre-screen interview, right? That they don't mention the fact that, a background check is going to be run until after conditional offer of employment. If you are utilizing an applicant tracking system, which are amazing and wonderful tools, make sure that if the reason that you are going to be rejecting someone is in whole or in part in the background check, that they don't get an auto rejection letter. They need the pre-adverse, the waiting, and then the adverse. No one likes to be told no more than once, right? And so certainly you don't want the pre-adverse, the waiting, the adverse, and then another sort of auto letter. The other thing is you could be violating the adverse action requirements, and that could potentially be a class action. So make sure that you understand, based on those statuses, what is going to go out to a person through your applicant tracking system if you have automated letters going out as well. State and local laws should be based, we talked about this, on where the position location is and the person's residential address, where they live or work. That's where they can sue you. Sometimes, people are saying, well, what about the remote environment? That's a challenge, right? But you do want to make sure that you understand where people are living and working so that you can apply those laws. And my favorite, and if you learn nothing else from today, hopefully you did, but my favorite is really, don't allow people or consider not allowing people to start before the check is done. You will have to pay them for potentially 5 business days if you take adverse action based in whole or in part on their report. They have access, or allow them to work for 5 business days. They have access to your people, to your property, to your customers. And it's a lot harder for morale in order to terminate someone than rejecting, if you want to follow the rules in the right way. Morgan?
And let me circle back to one thing that I forgot to follow up with you on as we were talking about pre-adverse action process. And so you mentioned the FCRA number and the dispute process. And one of the things we get asked about from end users, from clients is, okay, so this person says the background check is wrong. They're going to call in and dispute. Do I have to hold the job for them?
Great question. And the answer is, it's a little bit of a loophole in the FCRA, but let's be clear. By the time that you have recruited the person, they've applied, they've done the pre-screen interview, they've done the interview, maybe multiple interviews, you've gotten approval for the offer, you've given them an offer, they've accepted the offer, they've gone through the background check. This is your person. You want this person to pass the background check so that they can get hired into the role. You've invested a lot of time and energy. If the person is saying to you, there's a mistake on the background check, it's wrong, right? Obviously, the strong recommendation is to keep that job open for as long as you can, because that's that person's job. They may have detrimentally relied and quit another job. Shouldn't have, but they might have, right? And listen, mistakes happen, not often. But the reason that you've got the Fair Credit Reporting Act not being a strict liability statute, saying that your background check companies have to take reasonable procedures to ensure maximum possible accuracy, is sometimes courts have it wrong. Court information is incorrect. MVR information is incorrect. Sometimes there are manual errors, human errors that occur. That's why there is a dispute process. So the person can say before they are rejected, no, that's not a felony. That's a misdemeanor. Oh, okay, sorry. Then you actually are hired. We don't care if it's a misdemeanor, for example. Or, oh, that's Sally Smith. No, that's not me. It's a different Sally Smith. Because remember, it's an art, not a science. And so mistakes may happen. So that's the reason why I think it's really crucial, Morgan, in terms of what you were asking.
Yeah, and I know we agree on that. I just wanted to follow up on that for the attendees. And then the other thing for our attendees is, in terms of training managers and recruiters, I would just say treat this process as sensitively as possible, especially when the pre-adverse. I would handle it confidentially, only tell those who need to know, because someone, says, what's the status on my friend? And they said, oh, they're not getting hired. Whereas you've already sent them the pre-adverse, and it's something that could be used against you potentially. You never know but just in terms of training, sensitivity, confidentiality is important.
Well, and no good deed goes unpunished, right? I'll give you one last example before we wrap here, which is the situation of you get a background check in on a Friday night and the person's going to start on Monday, and the person calls in and says, hey, what's going on with my background check? And instead of them calling the background check specialist or someone who understands what to do and what to say, that the background check is pending at that point, because again, if it's pending or in review, we haven't done the pre-adverse, we haven't had the waiting time, we haven't done the adverse, you know, that unwitting and well-meaning manager could pick up the phone and say, oh, hey, it looks like you failed your background check. Well, guess what? That's an adverse action claim right there. And maybe on behalf of that person, or maybe on behalf of a class of people, because the person didn't know what to say. So you should have all background check questions really filtered to someone who knows. Your recruiters and managers should know and train to be saying that things are pending until that adverse action letter goes out.
Great content. Appreciate both of you spending some time with us today. So just a little bit of time here left. We're going to try and power through a couple quick questions. First one is, how often should an employer review their disclosure and authorization forms?
Sure, I would say at least annually. I think we talked about this. You know, obviously, anytime you get a notification or an alert, or you read something about new case law coming out, but definitely at least annually. And most of our employer clients do a check-in twice a year.
Gotcha.
And so just to follow up on that, Thomas, one of the things that I think is important for our attendees to take home is that you want a subject matter expert in background screening, reviewing your forms also. That's why we bring in Pam annually for Day with DISA. But you know, you don't need to use Pam necessarily. You need someone who's in touch with the law, because I've seen some really bad forms come across from people who aren't in the day-to-day weeds of the FCRA litigation. So just a reminder that make sure your attorney is up to speed on the litigation there.
Gotcha.
But you're welcome to use me if you want.
Yes,
Yeah,
of course.
absolutely.
Of course
They can
you're welcome.
definitely use Pam. Her information was on the slide just a second ago, and DISA certainly appreciates her expertise. Can't I just rely on my vendor to provide me with forms?
So let me take this one, which is, it's absolutely perfectly fine to get sample forms and documents from your background screening provider. However, you really should have those legally reviewed by your inside or outside counsel, because at the end of the day, they're only samples. And you want to make sure that you are complying with the law, and the buck will stop with you, because there's any sort of risk of exposure or liability will only be with the end user.
And then last question, I know we're up against it. Should I follow background laws from where an employee lives, works, or where my company is headquartered?
Right. So this is always a challenging one. But again, the best practice advice here, again, not legal advice, is to look to see the most conservative law where the person lives and or where the person is going to be having that job location. Where the company is may oftentimes be where the person works, but really where the company is a little bit less important. The only restriction that I would say on that is in Massachusetts. Massachusetts actually protects records, not people. Every other place and jurisdiction deal with consumer protection statutes. And if you take a step back and remember, that's really what the FCRA is. It's a consumer protection statute. It is meant to protect consumers, and as are most of these state and local laws. So again, where the person lives and or where the person may be performing their work.
Gotcha. Well, Pam, it's always a pleasure to work with you. Morgan, appreciate your time as well. Thank you so much, and thank you to everyone who attended today. Oh, and then one last shout out, Pam will be in another session in 2 days, this Thursday, talking about more in-depth background litigation strategies. So look forward to talking with you again, Pam.
Thanks, everyone.
Thanks all. Bye-bye.